Welcome to EU Privacy for All, Session 26 on GDPR, Security of Processing, Article 30. In the provisions suggested by European Parliament on the security of processing in Article 30, it was made really clear that both the controller and the processor shall take into account several factors, such as the results of a data protection impact assessment, and when assessing the measures to take, the state of the art and the cost of implementation. Also, a security policy long list of requirements was proposed by the Parliament. In the case of sensitive personal data processing, additional security measures were suggested. And finally, EDPB, the new Working Party 29, was supposed to be entrusted with the task of issuing guidelines, recommendations and best practices. On its side, EU Council made clear that the technology and the costs of implementation, but also the nature, scope, context and purposes of the processing, as well as the likelihood and severity of the risk for the rights and freedoms of individuals, shall be taken into account. Pseudonymization was presented as one of the appropriate technical and organizational measures to take. Also, approved code of conducts and certification mechanism were mentioned as being used as an element to demonstrate compliance. Additionally, in assessing the appropriate level of security, controllers and processors shall take into account particular risks for the rights and freedoms of data subject. Finally, both controller and processor shall take steps to ensure that any person acting under the authority of the controller directly or the processor shall only act under the instructions from the controller. In its final draft, Article 30 on the security of processing lays down that the controller and the processor shall take appropriate technical and organizational measures based on the state of the art, costs, nature, scope, context and purposes of the processing, as much as the risk of varying likelihood and severity for the rights and freedoms of individuals. It could include measures such as pseudonymization and encryption, the ability to ensure confidentiality, integrity, availability and resilience of systems, ability to restore the availability and access to data, and a process for testing, assessing and evaluating the effectiveness of technical and organizational measures regularly. In the following paragraphs, Article 30 also mentions that the assessment of the appropriate level of security shall be based on the risks to data protection. Adherence to approved code of conducts or certification mechanism may also demonstrate compliance. And finally, controllers and processors shall make sure that each person acting under their authority will act only on instructions from the controller unless required by union or member state law. Among other provisions, Recital 39 on the ability to take measures to ensure network and information system security, to resist malicious actions, unlawful actions or accidental events that would compromise the availability, authenticity, integrity and confidentiality of data, count among the legitimate interests of the data controller. This could include preventing unauthorized access and stopping denial of service attacks. Article 33.4 also reminds that in the frame of PIAs, notably, the controller shall seek the views of data subject without prejudice to the protection of the security of the processing operations. Article 38, 1a lays down that associations and other bodies representing categories of controllers or processors may prepare codes of conducts that would let down measures to ensure security of processing referred to in Article 30. Currently, Article 17 of the Directive also bases security of processing on a risks assessment. The controller, and the controller only, has the obligation to implement appropriate technical and organizational measures, in particular where the processing involves the transmission of data over a network, having due care about the state of the art and the cost of the implementation of measures. Member States shall provide that the controller must choose a processor providing sufficient guarantees regarding notably technical security measures and organizational measures governing the processing. In line with such a provision, the carrying out of processing by way of a processor must be governed by a contract or a legal act binding the processor to the controller, for acting only on its instructions and having the obligations incumbent on the controller being also incumbent on the processor. Finally, for the purposes of keeping proof, everything should be in writing. What should accountable data controllers and processors get prepared for? Keeping track of the fact that preparing security is based on assessment of privacy risks. More concretely, determine technical and organizational measures, including pseudonymization, encryption, the ability to ensure confidentiality, integrity, availability and resilience of systems, restore the availability in case of incident of access to data, regularly testing, assessing and evaluating the effectiveness of all technical and organizational measures, but also use code of conducts and approved certification mechanisms to demonstrate compliance. Act only by the instructions from the controller, except if required by a union or member state law. Ensuring that a network or an information system security, that is to say the ability to resist at a given level of confidence any action compromising the availability, authenticity, integrity and confidentiality, will be put in place. What will be interesting now is knowing more about EDPB or international standards guidance on the assessment of privacy risks, such as ISO 29134, and codes of conducts and certification approval process. How will it be framed?